appeals, three on the application of Faulkner and on the application of Sturnham against the Parole Board of England and Wales.
Lord Reid will give the judgment to the court.
As a result of legislation during the 1990s, life sentences nowadays begin with a period fixed by the court for the purposes of punishment and deterrence, known as a tariff. Once the tariff has expired, the only justification for further imprisonment is the protection of the public. In order to assess whether the prisoner presents an unacceptable risk to the public, his case is considered by the Parole Board at about the time the tariff expires, and he is released if he is assessed as no longer presenting an unacceptable risk. If he is not released at that point, he will be reassessed by the Parole Board at later intervals during his sentence. A number of criminal justice statutes enacted between 1997 and 2005 required the courts to pass automatic life sentences or indeterminate sentences for public protection on a wide range of persons who would not previously have received such sentences. Many of these persons had not committed especially serious offences and in consequence had short tariffs. The legislation therefore resulted, after a few years, in a very large increase in the number of prisoners whose tariffs had expired and who were then entitled to be considered for release by the board. The government had not, however, increased the resources of the board. The consequence was that prisoners faced delays before they could come before the board, and some of those prisoners continued to be imprisoned after they would have been released if the board had considered their cases at the proper time. In 1998, Parliament also passed the Human Rights Act, which gives legal force in the UK to Article 5.1 of the European Convention on Human Rights, which is a guarantee against arbitrary detention, and to Article 5.4, which requires the lawfulness of detention to be reviewed speedily. Another effect of the Human Rights Act was to provide a remedy in damages for breaches of those guarantees. The board and the government accept that prisoners who were deprived of their liberty for longer than they should have been as a result of the delays I have mentioned should be awarded damages. There is an issue, however, as to how much should be awarded. There is also an issue as to whether anything, and if so, how much, should be awarded to prisoners who did not serve any longer as a result of the delay, but who suffered stress and anxiety as a consequence of the delay. In the Human Rights Act, Parliament enacted that questions of this kind were to be answered taking into account the principles applied by the European Court of Human Rights. There is, in addition, an issue as to whether a prisoner who has been imprisoned for longer than he would have been if his case had been considered at the proper time is the victim of false imprisonment at common law, or of a violation of Article 5.1. These appeals are effectively test cases. Mr. Faulkner spent 10 months longer in prison than he should have done as a result of delay in his case being heard by the board. The Court of Appeal awarded him damages of £10,000. This court unanimously allows the board's appeal against that award and reduces it to £6,500. The court also rejects Mr. Faulkner's claim that he was a victim of false imprisonment on the basis that his imprisonment was at all times authorised by the relevant legislation. The court also rejects the argument that Mr. Faulkner was detained in breach of Article 5.1 on the basis that there was not such a breakdown of the parole system as to render his continued detention arbitrary. Mr. Sturnham did not spend any longer in prison than he should have done, but the hearing of his case by the board was delayed by 6 months. The judge at first instance awarded him £300 for the anxiety and stress which he was found to have suffered. The Court of Appeal allowed the government's appeal and quashed the award. Mr. Sturnham has appealed to this court against that decision. This court unanimously allows the appeal and finds that the award of £300 was reasonable in the light of the principles applied by the European Court. The judgments in this court, one by myself, with which Lord Newburger, Lord Manson, Lord Kerr agree, and a concurring judgment by Lord Carnwath, with which Lord Mance agrees, analyse the relevant European law in some detail and give general guidance as to how other cases of this kind should be dealt with in future.